All rise. Oh yay, oh yay, oh yay. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated.
We will call the only case on our docket is Klucas versus Sparrow et al. And we'll hear from the petitioners.
Lucy and Ricky Tacklepain in the city of Arcadia appears by Carey and Maria Drouhard and Christopher Pierron.
The respondent, the Ms. Sparrow, appears by Klucas and Robert.
We'll hear from counsel for the petitioner.
Chief Justice, Justices, and may it please the Court. My name is Chris Carey, and I represent petitioners Lucy and Ricky Tacklepain. With the Court's permission, I'd like to reserve 2 minutes for rebuttal. Police officers who defend the President should not be burdened with a lingering fear that the performance of their protective duties may render them personally liable in a retaliatory arrest lawsuit. For 2 reasons. This Court should require Sparrow to prove the absence of probable cause as an element of her 1983 claim. First, because Sparrow's arrest claim is analogous to the retaliatory prosecution claim, this Court gave a no probable cause rule in Hartman v. Moore. And second, because adopting an objective rule screens out frivolous retaliatory arrest lawsuits and ensures that police officers may perform their duties free from a lingering fear of litigation.
Are you asking for a rule that applies only to the President of the United States as an official, or would it apply to any public official?
No, Your Honor. We ask for a universal rule that applies to all retaliatory arrest claims, which is the approach this Court took in the Hartman decision. And I think that the easiest way to understand why that is necessary is to look at the reasons this Court gave in Hartman for applying a heightened standard of pleading and proof. And the first was that retaliatory prosecution cases involved issues of complex causation. And Sparrow's claim similarly involves an issue of complex causation. In Hartman, this Court identified that there was a gap between the animus possessed by one government official and the injurious action taken by the prosecutor, which presented additional factual difficulties. Here, in retaliatory arrest cases, the factual difficulty that makes the causation issue rather complex is that police officers often may legitimately take speech into consideration when deciding whether to arrest an individual. For instance,
political speech?
Yes, Your Honor. I think I would say expressive conduct. In the Hunter versus Bryant decision, this Court indicated that that concern is especially important where police officers are engaged in protective functions. And because officers sometimes may legitimately consider speech when deciding whether to arrest an individual, they would have to explain why their decision to arrest was a legitimate consideration of expression and not an illegitimate one that was motivated by animus.
Why isn't that for the fact finder? Why should that be a rule of law?
Well, because as this Court held in, or noted in the Crawford L decision on page 585, allegations of government misconduct are easy to allege and difficult to disprove, which is why this Court imposed an objective screening mechanism in the Hartman decision for retaliatory prosecution cases. And there's also an additional factual difficulty.
Let me ask you a question. You're saying that there's no difference between retaliatory prosecution and retaliatory arrest?
Not at all, Your Honor. I think that the easiest way to think about this is to put this Court's retaliation claims under 1983 on a spectrum. On one end, you have the Mount Healthy case, which involved the typical public employment retaliation claim. In those situations, there's a long-standing prior employment relationship between the employer and the employee, and there's a control period where there's no retaliatory conduct occurring, then the plaintiff engages in protective speech, and then the employer takes some retaliatory action, usually firing. On the other end of the spectrum, you have the Hartman decision, which gave a no probable cause rule to retaliatory prosecution claims. And retaliatory arrest cases are closer to that second end of the spectrum because the majority of these cases involve a one-time interaction between the police officer and the plaintiff.
But then doesn't that deprive the plaintiff of the right to put the issue of pretext before the fact finding?
Certainly not, Your Honor. And that speaks more to my second point about the need for an objective rule, but to briefly preview what our argument will be on that point. The fact is, if there was a concern that adopting our rule would result in an increase in pretextual arrests, we would have seen the effects of such a rule already. The vast majority of federal circuits adopt our no probable cause rule.
A vast majority?
Yes, Your Honor. The only circuit that's explicitly held after the Reichel decision and Hartman decision in 2006 and 2012 that they are going to adopt a not healthy approach is the Ford decision in the Ninth Circuit. There have been several decisions, there was one decision in the Sixth Circuit and in the Tenth Circuit, which suggested, I believe they decided on qualified immunity grounds, but expressed that they may be persuaded by that rule. But since this court's decision in Hartman, the vast majority of circuits have adopted our rule. And additionally, there are existing mechanisms in place that already reduce the likelihood of pretext for it to occur. 1983 is only one remedy which is available to plaintiffs.
What are the other remedies that you think are sufficiently efficacious that we could adopt new rule?
Of course, Your Honor. There are federal criminal and civil statutes for instance, for pattern of misconduct lawsuits that the government can bring when there's an allegation that a police force or individual officers have engaged in repeated instances of retaliatory action, including retaliatory arrests. And some states have also adopted laws.
So the state, because the state has the right to bring an action, that's an alternative remedy to the plaintiffs in this case bringing an action?
Yes, Your Honor. Again, this court does not, when it analyzes the elements of a constitutional tort under 1983, engages in a cost-benefit analysis. And in footnote 10 of Hartman, this court noted that there may be a possibility of the rare circumstance where an officer, or where a prosecutor is motivated by retaliatory animus, but that extremely unlikely event is not a reasonable basis to govern the vast majority of cases that do not include that retaliatory animus.
Haven't we historically provided the utmost protection for private citizens' free speech rights, political speech rights in the face of government action?
Yes, Your Honor, but that right does not exist in a vacuum. The officers in this case were protecting the president, and as I indicated earlier, they were permitted to take speech into consideration when determining the threat that someone poses to the President of the United States.
But what if they were motivated, and this is the allegation, by political speech that in fact was heckling the president? Why is that a valid basis then to arrest them on an unrelated charge, or disparage on the unrelated charge?
Again, Your Honor, a 1983 claim, first of all, is not the only remedy that is available to plaintiffs, and there are also some state laws that provide reliefs for private citizen suits, and as Justice Stevens noted in the Atwater decision, many states have adopted laws which limit the discretion of police officers to arrest when the only offense for which they have probable cause is a minor offense or a misdemeanor. So there would be a better case of retaliation in those state law claims. But
Okay, so in this case, what was Miss Sparrow, what was she arrested for?
she was arrested. The offense they told her that they had probable cause for at the time of the arrest was a violation of GPC Section 1001 for lying to a police officer. However, that stresses the importance of our rule because what the officer in this case observed was someone who had just slapped away the hands of the incoming president of the United States, the person they were assigned to protect, and they responded and reacted to that situation. And an officer should not have to consider...
But that's not why they arrested her. They didn't arrest her because they had probable cause to believe that she had assaulted the president or battered the president. Why didn't they just arrest her based on those grounds? I mean, they went and they arrested her for lying.
Yes, Your Honor, that is the offense for which she was arrested. However, this court in Reichel stressed the importance of adopting these objective standards for the police precisely for that reason, because the police should not have to consider before they act on their training and experience when they see someone slap.
But the allegation is they didn't act on their training and experience. They acted on their political affiliation with the president, who was demeaned by Ms. Sparrow, and that's why they acted to arrest her.
Of course, Your Honor, but again...
Well, of course, I mean, if that's the case, why shouldn't they bear some responsibility for that?
The allegations in the complaint are that they took those actions, but if this court were to adopt the Mount Healthy approach, which is the alternative to the no probable cause rule, then any such allegation would be sufficient to survive a motion to dismiss and subject police officers to litigation. So I will
Well,
say...
what's so bad about that?
Because it subjects police officers to the burdens this court continuously holds are important to protect against. In the Atwater decision, for example, at footnote 22, this court discussed how local police forces must divert their resources when their police officers are subjected to a significant amount of litigation about retaliatory speech. And
So how long did they spend interviewing her before they ultimately let her go and drop the charges? That seems like a significant amount of energy and time spent by our police force.
I believe that it was a few hours, Your Honor. However, again...
And they dropped the charges, right?
They did drop the charges. However...
Is there anything in the record to show why they dropped the charges?
There is not anything in the record that suggests why the charges were dropped. But again, the overwhelming majority of federal circuits adopt our rule, and as Justice Stevens indicated in the Atwater decision, this country is not confronting an epidemic of minor offense arrests, where the only offense that an officer had
No,
was...
instead, they're just shooting people in the back. That's a minor offense. I mean, your argument taken to another level in this environment today is really hard to believe. I mean, you've got officers that are shooting people in the back, in their grandma's backyard.
Well, yes, Your Honor, and I think that actually strengthens the case for an objective screening requirement, because most of those claims, I imagine, would involve an allegation of racial discrimination, which this court has adopted an objective screen under the Anderson case, which if you allege there was retaliation because of racial discrimination, you must show extremely detailed evidence laying out those allegations, precisely because the alternative is that it's very easy to make these allegations and subject officers to a retaliatory arrest lawsuit. And I think it's important to note that in the vast majority of cases, evidence of probable cause will exist.
Exactly. If if you throw your trash on the ground, there's probable cause to believe that you violated the city ordinance.
Well,
And so if they don't like what I'm saying, I'm arrested.
in the Reichel decision, Your Honor, this court noted that the rationale in Hartman was that the issue of probable cause was so likely to arise in the vast majority of cases that it could be made an added burden or an added element of the plaintiff's claim at little to no added expense. And that is similar in the context of retaliatory arrest cases, because of the 16 Federal Circuit opinions cited in the briefs in this case, every single one of those cases also involved either a warrantless arrest claim under 1983 or a state law false arrest claim, both of which require the plaintiff to show the absence of probable cause as an element of the offense. So that demonstrates that the issue of probable cause is so likely to arise that plaintiffs are not put at a disadvantage by requiring them to prove the absence of probable cause as an element of their offense.
So how does a person that, let's take a case where somebody is arrested and detained in retaliation for speech. How is the person to bring a claim like that? If you violate a city ordinance?
Well, if there was probable cause to arrest at the time the arrest occurred, our rule would hold that they do not have a 1983 claim. However, there would be alternative options available, and
you go to the police chief and ask them to look into it?
well, not just the police chief, Your Honor. There are federal lawsuits, or there are federal claims available and state law claims.
Under what statute?
Under, I believe it's 42 USC section 241 and 242. Those are the federal statutes which allow the federal government to bring a claim of pattern and practice of discrimination.
Right, but what claim would a victim have?
A victim of the, well, again, there are also state laws, some individual state laws, I don't have an exact number, I suppose, that provide relief for plaintiffs when there's an allegation of misconduct on the part of a police officer. But again, that stresses the importance of our rule because the majority of these cases involve a one-time interaction between the officer and the person who is a plaintiff, which is why we need an objective screen to prevent a wave of retaliatory lawsuits which burden police officers with frivolous litigation.
I believe you've used your time. It would be Justice Rankler. You're done. We'll hear from your co-counsel.
Chief Justice, Justices, may it please the Court. I am Maria Drouhard, and I represent petitioner, the City of Arcadia. Larry Nightingale does not have a legitimate expectation of privacy as the unauthorized driver of a rental vehicle. For two reasons, Arcadia's motion for judgment as a matter of law should be upheld. First, a bright-line rule against standing best serves the safe and efficient administration of justice. And second, a totality of the circumstances test is unnecessary when an unauthorized driver is found to be driving a rental vehicle. Therefore, this Court should adopt a bright-line rule against standing for unauthorized drivers of rental vehicles.
Well, if a bright line rule is so important, why don't we just adopt a bright line rule that does find standing? And that's equally well-defined.
Your Honor, that is the approach taken by the 8th and 9th Circuits, that a bright-line rule against standing exists unless the unauthorized driver can show that permission was granted by the authorized driver. However, that approach is insufficient for two reasons. First, the idea of permission is not a clear-cut standard that would be easily implemented by law enforcement officers, by the courts, and also by rental companies and unauthorized and authorized drivers alike. And secondly, in this case, although Nightingale is alleging he had permission from Sally Sparrow to drive the rental vehicle, that permission is too attenuated of a standard to serve as the rule going forward.
Why?
His permission from Sally Sparrow.
No, why is it
Too attenuated.
His permission is coming from the fact that she gave him the keys to the vehicle and he believed that she would have wanted him to drive the car. She never explicitly gave him permission, which in the 8th and 9th Circuit cases, permission always needed to be explicitly given by the authorized
Why is
driver.
it not explicit, giving someone the keys to the car?
Your Honor, giving someone the keys to the car could mean any number of things. It could mean you have my permission to go open the trunk to grab your luggage. It could mean go grab me a Kleenex from the car.
Yeah, but when you look at the totality of the circumstances, none of those apply.
Correct.
Here's like, I don't know how long I'm gonna be here in the police station, it could be years, so you better take the rental car back.
Yes, Your Honor. However, he had other reasonable options under those circumstances, and his permission is not from Sally Sparrow. It's from the contract that Sally Sparrow
Okay,
signed.
so let's talk about that for a minute. And I give you permission to drive my car. I hand you the keys, and well, in this case, I'll tell you, I'm expressly giving you my permission. But I don't own the car because I put $100 down, pickle, nickel, whatever that commercial is. So I put $100 down, and so I don't even have the title, okay, because there's a lien on it. Who owns that car?
Whoever has the title to that vehicle is the owner of the vehicle.
Okay, so have a nickel, give a pickle. They're the ones that have the lien. They're the ones that have the title. I don't have the title. So I can't give, if I owe any money on my car, if anybody has a lien on my car, I can't give you permission to drive it.
No, Your Honor. I believe when officers make a traffic stop, they ask for license and registration, and the owner of the vehicle is determined in that instance. Here, when the officers...
That's not what you said. You said whoever has title. Okay?
I'm
So
sorry.
registration, the car is registered in my name, but I don't have a title.
So in this case, I believe under state law, understanding that registration is sufficient to give you that possessory interest in order to give you a legitimate expectation of privacy in the
And could
vehicle.
we compare that in this instance to her having a rental contract, giving her permission?
No, Your Honor, because here, her limited possessory interest is only found under the contract she signed with Utopia, the owner of the vehicle, and she specifically signed away her right to transfer possession of that vehicle to anybody not listed on the rental agreement.
Why should someone's Fourth Amendment rights, which are protection against unreasonable government intrusion, be limited by a private contract between other parties?
Your Honor, that goes back to this court's holding in Racus v. Illinois 40 years ago. Since that time, Racus has come to be understood as a proposition against passenger standing when it comes to a search of a vehicle. And here, similarly, Larry Nightingale's only possessory interest comes from that rental agreement that Sally Sparrow signed, which specifically denied her the ability to transfer possession. And so under the second prong of the Katz test, penned by Justice Harlan in his concurrence in that case, this assertion of privacy would not be reasonable because it's not under that contract. And that contract...
Well, it seems to me that's circular argument.
It's a third-party contract.
Yeah, how does that limit the constitutional rights of
Mr. Nightingale.
Larry Nightingale?
Your Honor, because his possessory interests in the vehicle, which would grant him standing, are only found under the rental contract that he's asserting Sally Sparrow gave him permission under the contract to be in legal possession of that vehicle. In order to invoke...
Was he guilty of a crime by having the vehicle?
No, Your Honor, he's not guilty of a crime. However, when this court in Racus defined what a legitimate expectation of privacy was, they used in footnote 12 that they required that that expectation not stem from wrongful conduct. And wrongful is not the same as illegal conduct or criminal conduct, but conduct that's not right. Conduct here that would be wrongful because he is violating the terms of that contract. In Minnesota v. Olson...
What if we had a situation where Mr. Nightingale was driving and Ms. Sparrow was passed out in the back seat, say, and he's not an authorized driver? Does he have standing at that point when she's there in the car?
No, Your Honor, because under the contract he's not listed as an authorized driver, and so Utopia Inc. had no control over his limits to that car. He is not subjecting himself to the terms of that contract, and yet is asserting a privacy interest that would be under that contract.
What if I rented a hotel room and it said only the guests listed on the register would be in the room, and I forget to list somebody and they're there? Do they have an expectation of privacy that would be protected in the Fourth Amendment, or have I signed away their constitutional rights?
Your Honor, in that situation, I believe that the unauthorized guest would have an expectation because this court has routinely distinguished between the higher levels of privacy expected in one's home and the much lower levels of privacy expected in vehicles. Therefore...
Okay, let's say that it's a recreational vehicle on wheels.
That would be a much harder case, Your Honor. I believe this court has distinguished between the use of that vehicle, if it's being used as a mode of transportation versus the mode of housing somebody.
Let me ask you this. It seems to me, and tell me where my analysis is flawed. It seems to me that the reason for the contract between the rental company and the driver is to protect the insurance company in case there's any damage to the car.
I believe, yes, Your Honor, that would be part of the reason for that rental
What
contract.
other reasons are there?
It also is to ensure that the car is being used for specific purposes, that the renter knows when it's due back.
Specific purposes.
Many times, Your Honor, when we are confronted, and the courts are confronted with cases where an unauthorized driver is driving a rental vehicle, there's some nefarious purpose at play. Generally, it's trafficking of drugs, but sometimes the unauthorized driver didn't have a valid
Are
driver's
there facts
license.
that in the record to support what you're saying?
No, Your Honor, not in this case, but in general, when police pull over a car that has an unauthorized driver driving, there is some purpose, some illicit purpose for that unauthorized driver to be driving.
Where are you getting this?
In many of the Fourth Circuit cases, including Rollins v. U.S., the driver had, I believe it was cocaine.
Okay, so you're giving one example, but you're stating like almost as an expert, that if a non-authorized driver is driving, that you can presume a nefarious purpose.
Because it is so often in front of the courts that is the situation. There are cases where the unauthorized driver would not have been able to drive the vehicle, would not have been able to sign the rental contract because the driver did not have a driver's license, or his driver's license had been suspended. And that Utopia and other rental companies have an interest in ensuring that their vehicles are used by those who have who can drive legally by having a driver's license, or who understand that there are terms to their contract that they must subject themselves to.
That's all well and good for the relationship between the driver and the company, but why does that extinguish the Fourth Amendment right of someone who is driving the car ostensibly with permission of the person who's rented it?
Because the authorized driver does not legally have the ability to transfer possession under the rental contract. Sally Sparrow's Fourth Amendment protection stems from that rental contract. There's no other place that she could derive her privacy interest from other than, I mean, if it's possession alone, that's the same privacy interest a car thief could claim. And so that can't be where she's getting her legitimate expectation of privacy. But she cannot transfer that expectation of privacy because it's not found as reasonable under that contract.
Why is it unreasonable for someone who has permission of the person who rented the car to believe that they don't have the same expectation of privacy?
This court, Your Honor, wrote in Minnesota v. Olson, few house guests will invite others to visit them while they are guests without consulting the hosts. That's the same principle that this contract codifies and formalizes, that a guest cannot invite some stranger
Well,
to
that
a host's
makes sense.
house.
I mean, that sounds a little dicta-ish there. I don't think that's a holding in the case, is it?
It is not the holding, but it was used to support the rationale that this is not an expectation that society would find is reasonable, which turning to the need for, that there's no need for totality of the circumstances test here. 6 of the 7 circuits that have looked to this issue have found that a bright line rule is the best way to handle this. And when we look to the officer risk when it comes to routine traffic stops, at footnote 5 of U.S. v. Robinson, this court noticed that a significant percentage of police officer murders occur when the law enforcement officer is making a routine traffic stop. It is when an officer is at the highest risk of danger. And like I had mentioned earlier, when you're not listed on a rental contract, there is some evidence to support that there could be a nefarious purpose behind the lack of getting authorized permission to drive. Here, the facts, as stated on the record at pages 4 and 5, are that Officer Nunn was making a routine traffic stop, putting herself at a higher risk. She noticed a firearm in plain view near the presidential rally with a driver whose name was not listed on the rental contract. She should not have to second-guess her decisions to protect herself and the general public. Law enforcement officers quickly and often make these determinations in the field. They do not need to subject themselves to these cumbersome tests with undefined
We sure wouldn't
terms.
want to be cumbersome by, by actually implementing the Constitution.
Your Honor, the 5 factors test that the 6th Circuit determined in U.S. v. Smith is a cumbersome test. It looks to 5 factors without giving any discretion on how those factors are combined together, on what qualifies as being reasonable under those factors. And this court in Atwater wrote that we do not want to turn every discretionary judgment into an opportunity for constitutional review.
That sounds like more of an argument for qualified immunity, which has been waived in this case than a standing issue, isn't it?
Yes, Your Honor. But
Well, then why are you making an argument to us that on a question that's not in front of us?
I'm sorry, Your Honor. I'll go back to rate this. At page 147, this court wrote that when little would be lost and much would be gained by abandoning a case-by-case analysis, they have not hesitated to establish a bright-line rule. Here, Nightingale does not have a legitimate expectation of privacy because he's not listed under the contract that would have given him the legitimate possession of the vehicle. Society is not prepared to accept wrongful action as the source of Society is not prepared to accept his reasonable assertion of privacy, and there's no need for totality of the circumstances, given the lower starting expectation of privacy and the high risk to officers. Therefore, this court should adopt a predictable, straightforward, easily implemented bright-line rule against standing for unauthorized drivers. Thank you.
Thank you.
Chief Justice, Your Honors, and may it please the Court. My name is Kyle Klucas, and along with Robert Teutsch, we will be representing the respondent in today's matter. I will be speaking first for 15 minutes on the first certified issue regarding the guarantee of free speech. That guarantee of free speech in the Constitution is not just a static right. Instead, it is an enduring protection that is intended to be enshrined even in the harshest political environments. Today, we are asking this court to extend that protection to a political activist who is doing her absolute civic duty by protesting a president with whom she disagreed. Petitioner argues that because Officer Taklefane had some probable cause to arrest her, he was justified in silencing her free speech, no matter how driven by animus or pretextual it may have been. But as John Milton wisely noted, the timeliest and most effectual way of silencing free speech in a nation is to start arresting them for what they say. In reverence of that principle, we
But in this particular case, there was probable cause to make an arrest. Does it then matter? I mean, what's the causal link between the harm and the First Amendment right?
Yes, Your Honor. The existence of probable cause is not an issue, and neither parties are arguing about it. But what we are contending is that if probable cause did exist, there was something below it, potentially a pretext filled with animus to silence free speech.
Counsel, don't we have, I can't remember its name right now, Supreme Court decision that says a patrolling officer can stop a motor vehicle for a very minor traffic offense and do so because that officer suspects the person is doing something wrong, not because there's any probable cause or even reasonable suspicion that they're doing something. What do you think about that ruling, and how does that affect an argument that you have here?
I'm not sure of that exact case, Your Honor, and I'm also not sure that that would change necessarily what we're contending. If that initial stop occurred or if an arrest occurred as a result of an animus-driven reason in violation of a constitutional right, then this court should indeed say that that course of action is inappropriate for the officer.
Well, I wish I had done some research before I came down here. But we do have a United States Supreme Court decision written by, unsurprisingly, Justice Scalia, which said that you can see somebody doing a minor traffic offense that you generally wouldn't bother with, but because they're in the wrong race or driving the wrong kind of motor vehicle, you pull them over. And even if you've got a suspect reason that you testified to, our courts have said, well, that's okay as long as there was an illegal act where you could hang your hat.
Your Honor, I think that that case would implicate the Fourth Amendment and the reasonable searches, stops, seizures rule, as opposed to the First Amendment, which, as Your Honor's noted, is highly enshrined, particularly in political events like this. There are two reasons that this court must affirm the decision of the 14th Circuit Court of Appeals. First, because a probable cause bar is only appropriate in retaliatory prosecution cases, which this case does not bear similarity to. And second, because the Mount Healthy standard, which shifts the burden back and forth between the two individuals, is the most appropriate, as it does not sacrifice fairness for expediency. First, the probable cause bar in retaliation claims should only occur in retaliatory prosecution cases, which differ significantly from retaliatory arrest cases. As a general matter, this court holds retaliation causes of action to the Mount Healthy rule, which has been previously discussed. However, in Hartman, they noted a narrow exception by which a plaintiff would have to plead and prove lack of probable cause for retaliatory arrest for three reasons. First, because of the presumption of regularity that prosecutors receive in the prosecutorial decision-making. Second, because of the probative weight of probable cause in such determinations. And third, because of the complex issues of proximate and cause in fact that are involved in such determinations.
What do you make of petitioner's argument that we would be opening the floodgate to lawsuits against law enforcement officers that are easy to allege, difficult to prove, and will drain their resources and municipalities' resources in responding to those laws?
I firmly disagree with that contention, Your Honor. As this court noted in Crawford L., a host of pretrial screening procedures, occasionally heightened summary judgment standards, and the ability for a trial judge to curtail discovery to not be too difficult for a police department to respond to would make these concerns unimportant.
These cases are intent-based, aren't they?
Yes, Your Honor, they're mixed both.
Doesn't that become very difficult to respond and disprove the intent in advance of the trial?
No, Your Honor, we don't think it makes it too difficult for it to be implemented. To be sure, this test does require a little more than the probable cause bar, but it is the fairest. Officers are often able to win their cases using circumstantial evidence, the existence of a handbook, expert testimony that they oftentimes have on hand, and evidence of disparate impact of their actions in order to prove their case. And oftentimes in the circuits below, courts that use the Mount Healthy test find in favor of officers somewhat frequently. What we're suggesting is not that plaintiffs should automatically win if they have a First Amendment complaint, just that they ought to have some remedy. First, the presumption of regularity is not present in retaliatory arrest cases. The presumption states that when an official has a presumption of regularity, absent contrary evidence, they'll be assumed to have discharged their duties correctly. The Hartman Court noted that since prosecutors have that presumption, trial court would necessarily have to defer to their probable cause because of it, which means that in order for a plaintiff to state a case, they would need to prove that probable cause didn't exist.
So you're saying that there's no presumption of regularity when an officer arrests someone for probable cause?
This court in Reichel said that officers do not have a presumption of regularity. They noted all of the reasons that officers are given discretion and the importance of those functions, but stated those go to qualified immunity as opposed to an absolute presumption of regularity. This is indeed appropriate. As my co-counsel is about to argue passionately for 15 minutes, we often look into the motivations of police officers under the Fourth Amendment, so a probable cause bar would be inappropriate. The second difference between retaliatory arrest and prosecution is the lower probative weight of probable cause in such determinations. In Hartman, the court discussed at length how oftentimes a prosecutor, once they find probable cause, has an obligation to do something about it. But this is not the case in an arrest situation. In Atwater, the court noted that probable cause exists in virtually every single circumstance. And in Inwater, this court cautioned officers not to jump to arrest whenever they have probable cause because it exists so often. Since it exists in most cases, it's not dispositive and even really all that probative about whether or not animus existed. There are two examples to illustrate this point. First, if Ms. Sparrow had given her speech and then incited her audience to flip over cars, of course Officer Togolfang would have had probable cause to arrest her. But in the second instance, if she'd given the same speech and, say, tossed an apple core on the ground in violation of the city's municipal littering ordinance, the officer likely also would have had probable cause to arrest her. The point is that the mere presence of probable cause tells us nothing about the animus that existed. Now, of course, like in the above example, the sort of probable cause that exists can tell us a lot about whether or not there was animus. But under petitioner's rule, we would never be able to get at that question.
And if you apply the Mount Healthy test, you would look at whether the same decision would have been made absent the animus.
Yes, sir.
How in an isolated case like this would a plaintiff prove that in 1983 Act?
Your Honor, it's oftentimes done, like I mentioned, through circumstantial evidence, testimony from the officer or other officers about what they would have done. And a really important piece of evidence that exists is the officer's handbook about what they're to do in that circumstance.
This was kind of an interesting, extraordinary circumstance where actually the officer saw that Ms. Sparrow physically hit the president's hand.
Yes, Your Honor, that's true. But first, we'd like to highlight that was not the reason she was arrested. She was not arrested when she slapped the president's hand. She was not arrested the first time she lied, which already fulfilled the elements of probable cause here. But she was arrested only after the officers confirmed that she was the individual giving the speech that they disagreed with.
But wouldn't that say, well, it looks like the police were trying to exercise, caution, and we should reward that kind of action. They waited until she had done something, not just once but twice, that could be evaluated as a disturbance of the peace, especially with the near proximity of the President of the United States.
That's certainly a way to view the facts, Your Honor.
And in fact, what Judge Pierron is saying is that that gets beyond the probable cause to a totality of circumstances, that you're actually weighing whether or not, it was pretextual, right?
These are all sorts of evidence that could be put on before the fact finder, and we believe that this would be an appropriate factual determination for the court, rather than tossing out all of these cases by a categorical rule. Finally, the complex causation that exists in retaliatory prosecution cases does not exist in arrest cases for two reasons. First, the obvious reason, retaliatory arrest cases only involve usually a single person and their animus, whereas retaliatory prosecution involve a number of individuals. But second, and perhaps more important jurisprudentially, there's a difference with how the level of immunity that each official has affects the way that the trial will go on for complexity's sake. Prosecutors in Hartman, the court noted, have absolute immunity, which means that they can't be called in to testify about whether or not, on the dispositive question, they were influenced in order to prosecute. So, the court reasoned they needed a pleading standard in order to, quote, bridge the gap.
What would be the result in a case such as this, where the prosecutor decided, in fact, there was probable cause to proceed, didn't drop charges, and there was a conviction? Is there a cause of action still for retaliatory arrest in that circumstance if the officers were motivated by the speech to initiate the process?
I believe so, yes, Your Honor.
And what are the damages in that situation?
They would be 1983 damages, similar to where we stop here. But this would still demonstrate that the level of complex causality does not exist in these circumstances. Petitioner notes that there are still some complexities, as we've already discussed. This court should not be willing to sacrifice them, or the ability for plaintiffs to have some remedy at all, in order for expediency of officers, and indeed a probable cause rule should not be used. However, the Mount Healthy test is clearly the appropriate test. In Mount Healthy, the court developed a two-part standard. First, the plaintiff must prove a prima facie case that there was an injury of a constitutional right and that a substantial motivating factor of that injury was animus. Second, the burden shifts to the officer, and they must demonstrate through the evidence that we've already talked about that they would have made the arrest anyway. There are two reasons that this standard is appropriate. First and foremost, because it provides at least some remedy to plaintiffs in this circumstance and wouldn't chill free speech nearly as much. The facts here are important. As we've already discussed, she was only arrested after they confirmed that she was the one giving the speech that they disagreed with. The one that they signed up to support the president because of their disagreement. This court has defined the chilling of free speech as causing an individual to think twice about whether or not they would express otherwise permissible free speech. And indeed, knowing what she knows now, Ms. Sparrow certainly would think twice. Not only would she think twice, but it would likely chill other individuals at the rally who thought the leader of a counter-protest be arrested only after it was confirmed what she said. And finally, altogether, it would massively chill free speech if individuals knew that they had no remedy. Petitioner contends that we have not seen a massive rise in these sorts of cases in circuits that have adopted the rule that they suggest. However, of course we haven't seen them because they are barred at the probable cause stage, which would prevent them from ever receiving a remedy. They also suggest that an appropriate remedy is pattern lawsuits. However, by their own contention, these cases are often based on single interactions with individuals who would not be able to bring a subsequent case on that matter. As a result, this court should not allow police officers to violate First Amendment rights and then hunt out probable cause afterwards and violate the rights of the First Amendment. But the second reason that this standard is appropriate is because it really isn't that high of a bar. As the court in Crawford L noted, the use of circumstantial evidence and a host of other pieces of evidence, which the police officers oftentimes have better access to, are able to let police officers have a cogent argument and prove that they would have made the arrest anyway.
What sort of evidence would that be?
So circumstantial evidence like they were also doing something else that would have arrested them for, testimony on the stand about sort of the state of mind that day, the surrounding
It's self-serving, isn't it?
Yes, Your Honor, but we think the credibility of that would be something that the jury should get to determine. But also the existence of a guidebook, expert testimony, and evidence of disparate impact are all important in these determinations. But these officers, they also have the protections that they currently have in the status quo, such as qualified immunity, pretrial screening, and the curtailment of discovery that we've already talked about. Indeed, officers would not just lose willy-nilly under the standard, it would just be one that allowed plaintiffs some remedy. Because retaliatory arrest differs substantially from retaliatory prosecution, And because the Mount Healthy test is the appropriate one, this court must affirm the decision of the 14th Circuit Court of Appeals. Now, this is not always the easiest or most expedient test, but it is certainly the most fair and the one that comports best with this court's understanding of the guarantee of free speech in the First Amendment. Thank you.
Thank you.
Chief Justice, Justices, and may it please the Court. My name is Robert Teutsch. I'm representing respondents, and I will be discussing Mr. Nightingale's standing to challenge the search of a rental vehicle which he booked, paid for, and drove. As Your Honors noted, the boilerplate terms of a car rental agreement do not trump the fundamental Fourth Amendment right to be secure against unreasonable searches and seizures. This court in Klucas in 1978 said that a person has standing to challenge the search of a space if he or she has a legitimate expectation of privacy in that space. Mr. Nightingale had a legitimate expectation of privacy for at least two reasons. First, this court's jurisprudence has made it clear that a person need not have a legal possessory or property interest in a space to have a legitimate expectation of privacy. Second, applying a totality of circumstances test, Mr. Nightingale clearly had a legitimate expectation of privacy.
What are the circumstances that suggest that he had a legitimate expectation?
Yes, Your Honor, we can look to the Sixth Circuit's Smith case for some factors in applying a totality of circumstance test. And the most important factor the Smith court noted is a substantial business relationship with the car rental company. And here, Mr. Nightingale had such relationship because he booked and paid for the car rental. And also, had he been present with Miss Sparrow at the time of the car rental, he probably would have also been listed on the car rental agreement as well. Additionally, the evidence, pages 2 and 4 of the record, suggests that Mr. Nightingale had implicit permission from Miss Sparrow to drive the rental car. For example, he booked and paid for the car. He had a close personal relationship with Miss Sparrow. They had known each other for 6 years. They had driven together to the political rally and were going to drive back together. And
So is this something that an officer needs to interview? You know, this was a stop where he was, like a roadblock. They stopped every third person. So should an officer go into all that once you're not on the rental agreement? Do you have a close personal relationship with the person that is on the rental agreement? I mean, is that a burden that the officer should bear?
Yes, Your Honor, it is a burden that the police should bear because this is the way that we will preserve the Fourth Amendment rights enshrined in our Constitution. However, the case is not as dire as it seems. For example, a police officer can search a vehicle even if standing is present if there is probable cause. And with probable cause...
Since you're bringing that up, and I know it's not part of the question, but if an officer in plain view, legitimately stops a car, which has happened here, and in plain view, just seeing, they're outside the space, they're not searching, the plain view sees what he or she believes to be a weapon, isn't that probable cause to search the car?
Yes, Your Honor. If it is illegal to have a weapon in your vehicle while driving, then that could be probable cause. However, in this case, there's a dispute as to whether the plain view doctrine would apply at all since the gun was partially concealed. And additionally...
Wasn't there testimony that the officer believed that that's what it was, even based on the partial showing?
That's what the officer testified.
Based on their experience and training, etc.?
Yes. However, right now we're trying to decide whether Mr. Nightingale has standing. We're not arguing the underlying merits of the case.
Isn't there a virtue, at least going forward, with a bright line rule that it is in fact a bright line rule and everybody knows where they stand from that point forward? And wouldn't it be virtuous of us to establish such a rule?
2 points, Your Honor. Adopting the 4th, 5th, and 10th Circuit's bright line rule that hinges an expectation of privacy on what a contract says would simply not protect 4th Amendment rights. However, if this court would not like to adopt a totality of circumstances approach, it could adopt the bright line rule of the 8th and 9th Circuit, which hinged an expectation of privacy on permission from an authorized driver. And because the record suggests there was implicit permission, Mr. Nightingale would still prevail.
Well, I think petitioners would suggest that gets us into a totality of the circumstances, if only on the narrow issue of permission. I mean, is that a better rule, or does it just narrow the swamp that we're going to have to wade through?
Your Honor, I think that this court should adopt a totality of circumstances approach because this is what this court and the Raucus decision suggested it would adopt. For example, in Raucus, this court explicitly declined to adopt a bright line test, the legitimately on the premises test, in favor of a test that considers multiple factors. For example, in a concurring opinion, Justice Powell said, in considering the reasonableness of assertive privacy expectations, the court has recognized that no single factor will invariably be determinative. Thus, this court has suggested that because Fourth Amendment rights are so important, it's important to look at all the factors that might affect a legitimate expectation of privacy. And there's reason to suggest that society would view Mr. Nightingale's expectation of privacy as reasonable and as legitimate.
Well, but as I said, going forward, if we announce a Fourth Amendment rule that says, unless you're on the contract of a rental car, you have no expectation of privacy for Fourth Amendment purposes, someone's going to know whether they're on the rental contract or not. Doesn't that just clear out a whole bunch of underbrush and give us an easy way forward for the district courts, people who rent cars and people who borrow cars from people who have rented them? And isn't that ultimately a better rule?
Your Honor, the ease of implementation of a rule is important, but it should not be the dispositive factor. As this court, as my co-counsel noted, a totality of circumstances approach is not the easiest test to apply, but it's certainly the fairest. And as Your Honors noted, there are certain absurd results that would result if we were to base standing solely on what a third-party contract said. For example, the case where Miss Sparrow is passed out in the back of the car and Mr. Nightingale is not able to drive and still have standing if he happens to be searched. That's an absurd result. And therefore, this court should not adopt a bright line rule according to the 4th, 5th, and 10th Circuits approach.
Counsel, don't we already say if you're in a motor vehicle that is stopped, the officer has the authority to get everyone out of the vehicle, whether they were driving or not? Don't we say that is okay?
Yes, Your Honor, although I'm not sure that speaks to whether or not there still might be standing in the search of the vehicle. So they might be able to get him out and ask questions. But if Mr. Nightingale had standing and there was no probable cause to search the vehicle, then it would be, under the 4th Amendment, an unconstitutional search.
Well, didn't we have in the past, before, was it Chambers versus New Hampshire? Didn't we used to have to get search warrants to search vehicles, but then we changed the law and said if there's mere probable cause, you see something in plain view, you could go ahead and proceed and search.
Yes, Your Honor. Police officers do not need a warrant to search a vehicle. They do need probable cause, however. But we're not deciding, and in this proceeding today whether or not Mr. Nightingale, or whether Officer Nod had probable cause. We're just deciding whether Mr. Nightingale had a legitimate expectation of privacy in the vehicle. And applying a totality of circumstances test suggests that he would. He had a significant business relationship with the car rental company. He had implicit permission from Ms. Sparrow to drive the rental car. The relationship between Ms. Sparrow and Mr. Nightingale is similar to, in the Smith test, a relationship that's strong enough that society would recognize as conferring a legitimate expectation of privacy. And furthermore, the way that circuits have uniformly handled overdue rental cars should inform how circuits and this court handles unauthorized vehicles. In the Cooper case decided by the 11th Circuit in 1998 and the Henderson decision decided by the 9th Circuit in 2001, this court held, or not this court, those courts held that a person has a legitimate expectation of privacy even if they drive a rental car past the rental car due date. Now this is a case where there is a breach of the rental car agreement. In fact, one might even say that there's conversion because they are driving the car against the wishes of the rental car company.
Is there an outer limit to that rule? I mean, I don't think you could probably have it a year later and claim that there wasn't something nefarious going on.
You're right, Honor, and that hasn't come up.
So what you're saying is it would be part of the totality of the circumstances.
Exactly. Similar to how how courts have handled overdue rental cars, they should apply a similar analysis with unauthorized rental car drivers. And
How far does that extend? Could Mr. Nightingale have then made availment of this rental car to his spouse, and would she have an expectation of privacy at that point? I mean, how far does that extend outward as opposed to by a timeline?
right, that would be something that would need to be considered in the totality of the circumstances, and with the key determination being the one set out in Raucus. Is it something that society would think is permissible or legitimate? And if so, then there would be standing. And if not, there would not be standing. But that case where that's the attenuated possessory interest is not the case we have before us. The only reason.
How close do we get to that, or how much attenuation is permissible under a totality of circumstances? Or is that left open on a case-by-case basis?
This court need not decide that for the purposes of this case because the only reason Mr. Nightingale didn't have explicit permission, for example, was because Ms. Sparrow was wrongfully arrested for exercising her First Amendment rights. However, this court, as it has commonly done, can come up with rules of thumb to help make the decision of the totality of circumstances decision easier to apply. For example, if they had just been acquaintances, had Ms. Sparrow never really spent much time with Mr. Nightingale, then this court could say, yeah, that's a case where there's clearly not a legitimate expectation of privacy. Or if Mr. Nightingale did not have a business relationship with the car rental company, he had not booked, he had not paid for it, he had not driven the vehicle, then this court could rule that's not a legitimate expectation of privacy.
That sounds like a lot of guidance to the lower court to me.
Well, Your Honor, respectfully, this is not the first totality of circumstances test that this court or other courts have applied. And furthermore, in order to preserve the important Fourth Amendment rights, it's necessary to have a rule that at least does not go as far as the 4th, 5th, and 10th Circuits test in hinging it all on a contract. And if this court would like to adopt a bright line test, then it should adopt the 8th and 9th Circuits test. For these reasons, because a possessory and property interest is not necessary for a legitimate expectation of privacy, and because under either a totality of circumstances test or the 8th and 9th Circuits test, Mr. Nightingale could prevail, we ask this court affirm the 14th Circuit. Thank you very much.
Thank you.
What's your rebuttal argument? You got 2 minutes, counsel.
Chief Justice, and may it please the court. 2 brief points on rebuttal. First, on the standing issue. Smith's complicated multi-factor test is contrary to this court's well-settled Fourth Amendment principles. As it seems my friends on the other side put it, the individual weight of these factors is not clear. It's not clear how many of the factors must be present in order for an individual to have standing. And this shows that adopting an objective bright-line rule provides easily implemented and administrable rules for the police.
Haven't we ruled on regarding the voluntariness of a confession? I mean, we use a totality of circumstances test there with 6 or 7 guidelines that are, basic, but you can go beyond those.
Well, I would point this court to what it said in Raucus, where there is little to be lost and much to be gained by rejecting the individual's totality of the circumstances in this case, especially considering that their test does not consider the most important aspect of the relationship, which is the contract and rental agreement, of which Larry Nightingale is not an authorized driver. And if I can move briefly to the issue of the retaliatory arrest lawsuit, I think it's telling that respondents get to the issue of complex causation at the end of their argument, because that's where this court started in Hartman. It said that it was the strongest justification for imposing a no probable cause requirement, because this court is not simply considering our rule, our objective no probable cause rule. The alternative is Mount Healthy's approach, which in the 9th Circuit merely requires that the plaintiff allege some allegation that retaliation played some role in the decision to arrest. As this court said in the Crawford decision, allegations of government misconduct are easy to allege and difficult to disprove. And the burdens that would be imposed on police officers with this court to adopt Mount Healthy for retaliatory arrest cases is simply too great. Thank you.
Thank you. We will take the case under advisement and issue an opinion in due course. Thank you.
All rise. This honorable court is now in recess.